has been repealed, and now we have a new act, which is the Consumer Protection Act 2019. The basic highlights of this act is that the definition of consumer is very nicely given in that. The act has defined that who is a consumer. Besides that, there are 6 rights which have been culled down in the act, which include the right to be protected against the marketing of goods and services which are hazardous to life and property. Earlier, also we had 6 rights, which was the right to safety, the right to choose, the right to be informed, the right to be heard, the right to seek redressal, and the right to consumer education. These are certain rights which everybody should know. We all should know that the moment we buy something, there's always in our mind that because there are so many things in the market, इतना ज्यादा हमारे पास choices होते हैं कि हमें ये समझ नहीं आता कि जो हमने खरीदा है वो सही है कि नहीं. Either we are getting a nice thing, a right thing or not, or we are being cheated in the market. So in order to protect ourselves from any type of cheating, from any type of forgery in the market, we need to know about our rights, the consumer rights. और ये ऐसा टॉपिक है जो कि सिर्फ academicians को नहीं जानना है, हम सारे लोग consumers हैं. तो because that is why I have invited the entire university, even the supporting staffs, हमारे जो supporting staffs हैं, उनको भी मैंने invite किया है. And that is why I am keeping this webinar bilingual, so that everybody should be comfortable to ask anything to our eminent speakers, because both the speakers, Professor Chandrapal Upadhyay ji, जो कि academician है, professor है, और वो इस field में, he's a professor in that field and he has excelled in that field. Apart from that, Justice Mrs. Deepa Sharma ji, because she is a member of the National Consumer Commission, she must be in daily coming across the practical aspects of the consumer protection, like what type of people they go to for consumer protection. हमारे यहाँ ये भी बहुत important है लोगों को जानना कि when we buy something, जो consumer forum है उसमें कैसे approach करें, कैसे जाएं, whether we require an advocate or not, whether we can ourselves become an advocate and practice आप अपने लिए लड़ सकते हैं, या फिर we need an advocate for that. So all these aspects are very important to know for a consumer, for anyone who is a consumer, because all of us are consumers. So it is in this light that I have invited Professor Chandrapal Upadhyay, who is our first speaker, and he will be speaking on the changing dimensions of consumer protection in India. Before I invite Professor Upadhyay, I would like to give a brief introduction about Professor Upadhyay. Professor Upadhyay has completed his PhD in August 2005 on changing dimensions of law relating to medical negligence. He was a UGC Merit Scholarship holder for the duration of his LLM and a JRF for his PhD. He started his teaching career at Agra College, Agra in July 1996 as a lecturer and went on to join law school BHU as a reader in November 2006. He became a professor in July 2011. Till date, 8 of his articles have been published in various national and international journals. He has chaired the technical sessions of seminars. He has also authored 1 book and has served as a convener of many committees. In the past, he has delivered lectures at several forums like the Academic Staff College, and he is now the coordinator of BA LLB Honours course at the Law School Banaras Hindu University. Professor Upadhyay, I invite you to give the
thank you
speech on changing dimensions of consumer protection in India.
Thank you, ma'am. Thank you very much. Honorable Vice Chancellor, Indira Gandhi National Open University, Professor Nageshwar Rao ji, Pro Vice Chancellor, Professor Sumitra Kukreti, Honorable Justice Ms. Deepa Sharma, Director, School of Law, IGNOU, Dr. Sunit Kumar Srivastava, and all the dignitaries on the dais. I welcome you all and very, very good morning to you all. First of all, I would like to congratulate you on this occasion of World Consumer Rights Day on the 15th March 2020. जैसा कि मैम ने अभी बताया आप लोगों को कि कंज्यूमर प्रोटेक्शन की दिशा में हमारे देश में जो फर्स्ट लेजिस्लेशन था वो था कंज्यूमर प्रोटेक्शन एक्ट 1986 एंड दैट वाज ए माइलस्टोन इन द फील्ड ऑफ कंज्यूमर लॉ. फर्स्ट टाइम कंज्यूमर्स के राइट को डिफाइन किया गया और एनुमरेट किया गया कि देयर आर सर्टेन राइट्स गिवन टू ऑल द कंज्यूमर्स, as well as there was a provision for adjudicatory authorities. If the rights of the consumers are violated, then they have not to go to ordinary civil court, but they can directly go to adjudicatory authorities provided under the Consumer Protection Act. So this is the very unique feature of the consumer protection law. But before going through all these things, I would like to quote a statement of that he has rightly said, consumers are to economics, are to politics. तो जैसे ही राजनीति में मतदाताओं का महत्व है, उसी प्रकार से अर्थशास्त्र के क्षेत्र में कंज्यूमर्स का बहुत ही इम्पोर्टेंस है और वो न केवल पर्सनल गेन के लिए उनके लिए लाभदायक है, बल्कि ये नेशनल इकोनॉमिक को भी अफेक्ट करता है. अगर कंज्यूमर को अच्छा प्रोटेक्शन मिलेगा, कंज्यूमर्स अगर हैप्पी होंगे तो नेशनल इकोनॉमी भी फ्लोरिश करेगी. कंज्यूमर्स आर रिगार्डेड एज द किंग ऑफ द मार्केट. उनको मार्केट का बादशाह माना जाता है. Contemporary era is marked as the era of consumers. Consumer is a relative term, and each of us is a consumer at some point of time. मतलब हम सभी लोग कंज्यूमर हैं. In the environment of limited choice, inadequate supply, incomplete information, and unlimited demand, there is more possibility that consumers may be cheated in the hands of businessmen and traders who are in superior position as compared to consumers. मतलब consumers की जो position है, they are weaker party in comparison to businessmen and traders and suppliers of the goods. So in this background, it is very important and relevant that we should talk about consumerism. Consumerism is all about protection of interest of consumers. It should not be considered as a war against the businessmen. कंज्यूमरिज्म का ये मतलब नहीं है कि हमें बिजनेस के खिलाफ लड़ाई लड़नी है, बल्कि हम ये कह सकते हैं कि इट इज ए कलेक्टिव कॉन्शियसनेस टू एनहांस द कंज्यूमर सेटिस्फैक्शन एंड सोशल वेलफेयर of the society. Consumerism is still in the infancy in our country due to sellers market and government monopoly in most of the services. हमारे देश में सेलर्स, जैसे मैंने आपको बताया कि दे आर इन स्ट्रांगर पोजीशन, दे आर स्ट्रांगर पार्टी, और अधिकांश सर्विसेज जो है वो गवर्नमेंट के क्षेत्राधिकार में है. इसलिए वहां पर बड़ी संभावना रहती है कि कंज्यूमर को न्याय मिल नहीं पाएगा. But the effect of the consumerism is emergence of consumers' rights. कंज्यूमरिज्म का जो मूवमेंट है, जो सोशल मूवमेंट है, इसका सबसे अच्छा जो परिणाम है, ये है इमरजेंस ऑफ कंज्यूमर्स राइट्स. और कंज्यूमर्स को जब राइट प्राप्त हो जाएंगे तो वे अपने राइट को प्राप्त करने के लिए, उसका वायलेशन होने पर रेमेडी के लिए एफर्ट कर सकते हैं. इन द मीन टाइम the consumer markets witnessed drastic transformation with the emergence of global supply chain, rise in international trade, rapid development of e-commerce, leading to new delivery system. मतलब अभी जो हमारा मार्केट है, जो कंज्यूमर मार्केट है, उसमें ही ड्रास्टिक चेंजेज आ गए हैं और वह इंटरनेशनलाइज हो चुका है. In this background, there are two strong enactments which are very much helpful to protect the rest of the consumer and promote their interest. दो ऐसे कानून बने हैं इस बीच जो कि कंज्यूमर्स के राइट प्रोटेक्ट करते हैं और उनके हितों को बढ़ावा देते हैं. इसमें एक कानून है कंपटीशन एक्ट 2002 और दूसरा लॉ है कंज्यूमर प्रोटेक्शन एक्ट 2019. दोनों लॉ कंज्यूमर के प्रोटेक्शन को टारगेट करते हैं, लेकिन दोनों का तरीका अलग अलग है. They protect the interest of the consumers differently. Consumer Protection Act does so explicitly, while Competition Act does so by necessary implication. The Consumer Protection Act addresses consumer disputes against traders directly, while Competition Act addresses consumer welfare indirectly by regulating the markets and ensuring more choices to the consumers. As I told you that the new Consumer Protection Act 2019 came into force from July 2020 by replacing, reforming, and repealing the earlier Act of Consumer Protection Act 1986. This 1986 can be said to be a boon for Indian consumers. This act was basically intended to provide for better protection and promotion of consumers' rights. This act was amended from time to time to make it in accordance with the changes in the market. However, the practical implementation was far from fulfilling its desired objective. दो महत्वपूर्ण परिवर्तन हुए हैं या इस इनेक्टमेंट के द्वारा दो महत्वपूर्ण परिवर्तन लाए गए हैं. पहला जो परिवर्तन है कि हमारा जो 1986 का कंज्यूमर प्रोटेक्शन लॉ था, दैट वाज बेस्ड ऑन द डॉक्ट्रिन ऑफ कैविएट एम्प्टर, क्रेता सावधान के सिद्धांत पर आधारित था. बट दिस कंज्यूमर प्रोटेक्शन एक्ट 2019 is based on the doctrine of इस अधिनियम के द्वारा यह स्पष्ट हो जाता है कि अब विक्रय का सिद्धांत आ गया है, सेलर बीवेयर इन प्लेस ऑफ बायर बीवेयर. नाउ इट हैज बीन सेलर बीवेयर. दूसरा परिवर्तन यह है कि कंज्यूमर प्रोटेक्शन एक्ट 1986 was not a class legislation, but if we study section 10 clause 1 of this act, now the Consumer Protection Act 2019 is protecting the interest of the consumers as the class legislation. So these are two additions in the Consumer Protection Act 2019, which were not in earlier law. For example, in the new act, there is provision for product liability. There is separate regulatory authority called as central authority, just like the Competition Commission of India. We find establishment of consumer mediation cells. There is punishment for misleading advertisements. The pecuniary jurisdiction of the consumers forum have been increased. The definition of goods and consumers has been modified, and appeal-related provisions have been made more stringent.
I think the link. I think the connection has been broken of Professor. I'm trying to call him. Please wait for a second. Till Professor Upadhyay joins us, it was a really very important session which he was talking about. He was talking about the new provisions which the new act, the Consumer Protection Act 2019 has, in the new Consumer Protection Act 2019, what are the new provisions which was not earlier than the Consumer Protection Act 1986. So he was talking about those. I would also like to give you a brief about what are the new provisions. The highlights of this act is the 2019 act is that it is better than the earlier act. As he already told, that the act in the earlier act, the act was based on the doctrine of caveat emptor, where यहाँ हम लोगों को the buyer had to be aware. If you're buying something, आपको ये जानना जरूरी है कि आप जो खरीद रहे हैं, आप खुद responsible हैं उसके लिए. तो Professor Upadhyay has joined. So I was telling Professor Upadhyay that as the earlier act was more based on the doctrine of caveat emptor, which you have already told, and the new act is based on the seller be aware. So यहाँ हमने seller के ऊपर ये जिम्मेदारी है कि उनको अवेयर होना चाहिए कि वो क्या बेच रहे हैं, और ये उनकी रिस्पॉन्सिबिलिटी है कि वो हमें गलत चीजें ना बेचें. तो ये यहाँ पर ये चेंज बहुत ही महत्वपूर्ण है, बिकॉज पहले एक्ट में था कि हमें खुद सोच समझ कर खरीदना था. अब यहाँ पर सेलर के ऊपर ये रिस्पॉन्सिबिलिटी आती है कि आप एडवर्टीजमेंट्स के सहारे कुछ भी हमें नहीं बेच सकते हैं, जो आप चाहे
Yes,
हमें नहीं
ma'am.
बेच सकते हैं, बिकॉज नाउ दे हैव टू बी मोर अवेयर व्हाट दे आर सेलिंग, और मिसलीडिंग एडवर्टीजमेंट्स वगैरह के सहारे वो हमें एल्यूर नहीं कर सकते हैं। तो जहां एज वी नो दैट कंज्यूमर इज द किंग, और कंज्यूमर बहुत ही इंपॉर्टेंट है कंज्यूमर का होना। अगर कंज्यूमर नहीं है तो फिर डेफिनेटली ये जो सारा मार्केट है वो बेकार है। तो प्लीज कंटिन्यू सर।
Okay, ma'am. Sorry, there was a poor internet connection. First of all, we will take up one by one every point. The first point is about product liability. The first time in this Consumer Protection Act, there is provision for the product liability. Product liability means अगर कोई प्रोडक्ट डिफेक्टिव है या उसके डिजाइन में अगर कोई कमी है, तो उसके लिए अगर लाइबिलिटी की जो बात आती थी, तो जो हमारा पुराना एक्ट था 1986 का, उसमें भी प्रावधान था, बट देयर वाज नॉट ए प्रोविजन फॉर द प्रोडक्ट लाइबिलिटी ऑफ द मैन्युफैक्चरर और रिटेलर। जो सेलर होते थे, दे मे बी हेल्ड लाइबल अप टू सर्टेन एक्सटेंट, बट नाउ एंड एज फार एज द लाइबिलिटी ऑफ द मैन्युफैक्चरर और रिटेलर इज कंसर्न्ड, हमें मतलब ऑर्डिनरी सिविल कोड का सहारा लेना पड़ता था, एंड दैट वाज वेरी टाइम टेकिंग एंड वेरी एक्सपेंसिव आल्सो. So this is a new provision, and this provision provides about the liability of the manufacturers and the retailers as well as the sellers of the goods. And the consumer who suffers the loss due to any defective good or any poor services of the service provider, he may be compensated from that retailer or manufacturer or the service provider. Actually, this act explicitly provides for the breakup of the liability of the product manufacturer, retailer, and product seller, and all of them may be held jointly or severally liable. मतलब उनका संयुक्त या पृथक दायित्व होगा और उन सभी को जिम्मेदार ठहराया जाएगा। तो ये बहुत बड़ा एक यूनिक फीचर है इस नए लेजिस्लेशन का, जो कि कंज्यूमर के लिए बड़ा हेल्पफुल होगा। और सेकेंड पॉइंट है मैम, इस्टेब्लिशमेंट ऑफ सेपरेट रेगुलेटरी अथॉरिटी, सेंट्रल कंज्यूमर प्रोटेक्शन अथॉरिटी, इट इज आल्सो नोन एज द सेंट्रल अथॉरिटी। और इस अथॉरिटी की संरचना है कि इसके राइट्स का अगर कोई वायलेशन होता है या कोई अनफेयर ट्रेड प्रैक्टिसेज की जाती हैं या कोई फॉल्स या मिसलीडिंग एडवर्टाइजमेंट होता है, तो उसको रोकने के लिए डायरेक्ट एम्पावर्ड है। इसके अतिरिक्त ये अथॉरिटी कंज्यूमर्स के राइट को प्रमोट करेगा, प्रोटेक्ट करेगा और उसको इन्फोर्स करेगा एक क्लास के रूप में। और सबसे बड़ी विशेषता है इस अथॉरिटी की कि इसके साथ एक इन्वेस्टिगेटिव विंग भी है, जो कि इन्वेस्टिगेशन का काम कर सकता है। जिस प्रकार से हमारे कंपटीशन लॉ में कंपटीशन कमीशन ऑफ इंडिया में डायरेक्टर जनरल होता है इन्वेस्टिगेशन करने के लिए, सिमिलरली देयर इज प्रोविजन अंडर द कंज्यूमर प्रोटेक्शन टू इन्वेस्टिगेट द मैटर्स। मतलब ही कैन the authority can order for the investigation of the matter suo motu or on the basis of the complaint of the consumer. तो ये बहुत बड़ा एक फीचर है कि इसमें इन्वेस्टिगेशन करने का भी पावर दे दिया गया है, और जो भी इन्वेस्टिगेशन का रिपोर्ट होगा अकॉर्डिंगली दे कैन फाइल द कंप्लेंट और दे कैन प्रोसिक्यूट द पर्सन्स or they can order for the recall of the unsafe goods and services, or they can pass order for the discontinuance of the unfair trade practices, or they can order for the reimbursement of the price, they can impose the penalties for the misleading advertisements. तो ये जो अथॉरिटी की का इस्टेब्लिशमेंट किया गया है, ये बहुत ही लाडेबल स्टेप है और यह कंज्यूमर के प्रोटेक्शन को बहुत ही एक्टिवली प्रोटेक्ट है कंज्यूमर्स को। एंड दिस द रेमेडी अगेंस्ट दिस order of the central authority is only that the person can go in appeal before the National Consumer Commission. मतलब अगर इस अथॉरिटी का कोई ऑर्डर आया है तो उस ऑर्डर के खिलाफ कंसर्न्ड पार्टी को केवल एक ही रेमेडी है कि वो नेशनल कमीशन में अपील कर सकता है इस ऑर्डर के अगेंस्ट में। तो बहुत ज़्यादा टाइम कंज्यूमिंग नहीं होगा और इजी रेमेडी दी जा सकती है इसके माध्यम से। और एक महत्वपूर्ण जो फीचर है इस न्यू लेजिस्लेशन का, वो है टू प्रोवाइड फॉर द अल्टरनेट डिस्प्यूट रिजोल्यूशन मैकेनिज्म इन द कंज्यूमर प्रोटेक्शन लॉ। जितने भी हमारे 3 टायर सिस्टम है कंज्यूमर कमीशंस का, डिस्ट्रिक्ट कमीशन, स्टेट कमीशन एंड नेशनल लेवल कमीशन, एट ऑल द लेवल्स उन कमीशन से जुड़े हुए मीडिएशन सेल की स्थापना की जाएगी, जिसमें देयर विल बी लिस्ट ऑफ द मीडिएटर्स एंड इफ द कमीशन थिंक्स दैट द मैटर शुड बी रिजॉल्व थ्रू द मीडिएशन, तो वो मामले को रेफर करेंगे और पार्टी अगर एग्री करती हैं तो मीडिएटर्स जो है वो मीडिएशन करने के बाद मीडिएशन रिपोर्ट तैयार करेंगे और उस रिपोर्ट को कंसर्न्ड कमीशन के पास भेज दिया जाएगा और जो कंसर्न्ड कमीशन होगा दैट शैल पास सुटेबल ऑर्डर एंड डिस्पोज द मैटर अकॉर्डिंगली। तो इस तरीके से मैडम एक इससे जो हमारे कमीशंस हैं उनका भी वर्कलोड कम हो जाएगा और समय की बचत होगी और कंसेंसस से ऑर्डर पास होगा तो पार्टीज को सेटिस्फेक्शन भी मिलेगा नेचुरली, एंड बट देयर विल बी नो अपील अगेंस्ट सच सेटलमेंट। मतलब इसके खिलाफ कोई अपील का प्रावधान नहीं होगा। इसी कंटिन्यूएशन में जो कुछ अमेंडमेंट किए गए हैं नए लेजिस्लेशन में, वो है कि इन्हांसमेंट ऑफ द पेकुनियरी जुरिस्डिक्शन ऑफ द कमीशंस। हमारा जो डिस्ट्रिक्ट कमीशन है इसके आर्थिक क्षेत्राधिकार को बढ़ा करके 1 करोड़ रुपए तक के मामले की सुनवाई करने का अधिकार दे दिया गया है। स्टेट कमीशंस को 1 करोड़ से लेकर के अप टू 10 करोड़ रुपीज तक के मामलों की सुनवाई का अधिकार दिया गया है और अगर 10 करोड़ रुपीज के ऊपर का कोई मामला है तो उसमें नेशनल कमीशन में सुनवाई का अधिकार दिया गया है। तो इस तरीके से जो इनका आर्थिक क्षेत्राधिकार बढ़ा दिया गया, सबसे बड़ा बेनिफिट होगा कि नेशनल कमीशन और स्टेट कमीशन पर वर्कलोड कम हो जाएगा। अब ज़्यादा से ज़्यादा मूल्य के मामले जो है वो डिस्ट्रिक्ट कमीशन के लेवल पर निपटारा किया जा सकता है और इससे स्टेट कमीशन और नेशनल कमीशन का वर्कलोड कम हो जाएगा। जहाँ तक टेरिटोरियल जुरिस्डिक्शन की बात है, एक बहुत अच्छा चेंज किया गया है इस इनैक्टमेंट में, नहीं था, और वो है कि दिस विल ईज द बर्डन ऑफ कंज्यूमर्स। पहले कंज्यूमर को या तो जहाँ प्रतिपक्षी रहता है या जहाँ पर कॉज ऑफ एक्शन अराइज होता है वहाँ पर कंप्लेंट फाइल करने की सुविधा थी, लेकिन नए इनैक्टमेंट में अब कंप्लेनेंट को अपने प्लेस ऑफ रेजिडेंस या अपने प्लेस ऑफ वर्क में भी कंप्लेंट फाइल करने की सुविधा दे दी गई है। अब इसके लिए अपने कंप्लेन के लिए उसको दूसरे जगह पर भटकना नहीं पड़ेगा। इसी प्रकार से अपील से रिलेटेड जो मामले हैं उनको थोड़ा स्ट्रिक्ट बना दिया गया है और स्टेट कमीशन के आर्डर के अगेंस्ट नेशनल कमीशन में अपील तभी की जा सकती है जबकि उस मामले में कोई सब्सटेंशियल क्वेश्चन ऑफ लॉ इन्वॉल्व हो। सब्सटेंशियल क्वेश्चन ऑफ लॉ अगर नहीं है तो सामान्यतः अपील की अनुमति नहीं होगी। और अगर कोई व्यक्ति नेशनल कमीशन के ऑर्डर के अगेंस्ट में सुप्रीम कोर्ट में अपील करना चाहता है तो वह तभी अपील कर सकता है जबकि वह मामला नेशनल कमीशन में ही इनिशियली फाइल हुआ हो, तभी वो अपील कर सकता है और सुप्रीम कोर्ट में जा सकता है। तो इस तरीके से अपील से रिलेटेड जो प्रावधान थे उनको थोड़ा सख्त बना दिया गया है और इसका परिणाम ये होगा कि मामलों का टाइमली डिस्पोजल हो जाएगा और द कमीशन विल प्रोवाइड द क्विक रेमेडी टू द कंसर्न पर्सन्स। और एक जो सबसे बड़ा परिवर्तन लाया गया है इस अधिनियम के द्वारा वह है with regard to authenticity and accountability of the advertisements। विज्ञापन को लेकर के जनता बहुत परेशान होती है और विज्ञापन के द्वारा प्रेरित भी होकर के लोग बहुत ही परेशान होते हैं। तो उन सारी चीज़ों को, विज्ञापन से संबंधित समस्याओं को रोकने के लिए, जैसा मैंने अभी बताया था कि सेंट्रल अथॉरिटी को पावर दिया गया है कि वो ये सुनिश्चित करे कि कोई भी झूठा या भ्रमपूर्ण विज्ञापन न होने पाए जो कि इस अधिनियम के प्रावधानों के उल्लंघन में हो। ऐसा कोई गलत या मिथ्या विज्ञापन न होने पाए और अगर ऐसा कोई विज्ञापन किया जाता है तो सेंट्रल अथॉरिटी उसको डिसकंटिन्यू करने के लिए या उसको मॉडिफाई करने के लिए आदेश दे सकता है या अगर उचित समझता है तो पेनाल्टी भी इम्पोज कर सकता है। और एक बार पेनाल्टी इम्पोज करने के बाद भी अगर बार बार विज्ञापन का उल्लंघन किया जाता है विज्ञापन के द्वारा तो पेनाल्टी और सख्त हो जाएगी और उसकी राशि बढ़ा दी जाएगी। साथ ही साथ यहाँ पर एक और महत्वपूर्ण बात है कि जो सेलिब्रिटीज ब्रांड एम्बेसडर के रूप में काम करते हैं विज्ञापन में, उनके लिए भी प्रावधान बना दिया गया है कि वो भी बहुत ही सावधानी के साथ और विज्ञापन की सत्यता परखने के बाद ही किसी भी कमोडिटी का विज्ञापन करेंगे, क्योंकि अगर वो ऐसा नहीं करते हैं तो उनके लिए भी पेनल प्रोविजन कर दिया गया है, उनको पेनलाइज किया जा सकता है। तो इन सारी चीज़ों के अतिरिक्त और भी कई छोटे छोटे बदलाव किए गए हैं। जैसे गुड्स की जो डिफिनीशन थी उसको और मॉडिफाई किया गया है और गुड्स के डिफिनीशन में फूड को भी शामिल कर दिया गया है। फूड का जो डेफिनेशन फूड सेफ्टी एंड स्टैंडर्ड एक्ट 2006 में दिया गया था उस डिफिनीशन को यहाँ इनकॉर्पोरेट किया गया है। अब इसका लाभ ये होगा कि जो फूड इंडस्ट्री, जो फूड डिलीवरी प्लेटफॉर्म्स डेवलप कर रहे हैं इस समय, दे विल आल्सो कम इन द परव्यू ऑफ द दिस एक्ट। तो उनके खिलाफ भी कंज्यूमर जा करके फोरम में रेमेडी ले सकता है। दूसरा जो बदलाव किया गया है वो द डेफिनेशन ऑफ कंज्यूमर हैज बीन ब्रॉडेंड and now it covers the transactions through all modes: offline mode, online mode, teleshopping, direct selling or multi-level marketing। मतलब every type of marketing has been included under the definition of consumers, and the persons who are marketing through any of these mediums, they will be treated as the consumer under the definition and they can avail the remedy under the consumer protection law. Thirdly, this new enactment provides swift and less time consuming process by enabling electronic filing of the complaint as well as वीडियो कॉन्फ्रेंसिंग। ये जो प्रावधान कर दिया गया है कि वीडियो कॉन्फ्रेंसिंग के द्वारा मामले की सुनवाई हो जाएगी या ई फाइलिंग ऑफ द कंप्लेंट्स हो सकता है, इलेक्ट्रॉनिक फाइलिंग है। और पार्टिकुलरली जो कोरोना पेंडेमिक के दौरान जो चेंजेस आए हैं उसका भी लाभ मिलेगा और कोरोना काल में ये लेजिस्लेशन भी बना था। तो कहने का मतलब ये है कि इससे और ही शीघ्रता से मामले का निपटारा किया जा सकता है और ये सारे परिवर्तन आए हैं। तो अभी तक तो मैंने सारी सकारात्मक बातें की हैं, इसमें कुछ प्रैक्टिकल प्रॉब्लम आ सकती है। देयर आर सो मेनी लैकुना, बट वी शुड नॉट think negatively, we should be positive. Or lastly, I would like to say that this is not an old wine in new bottle, but this is new wine in new bottle.
Thank you so much, Professor Upadhyay. You have, after listening to Professor Upadhyay, I hope हम लोगों के मन में जितनी भी बहुत सारी चीजें थी कि एज ए कंज्यूमर हमें we will get justice or not and how we will protect ourselves, वो सारी चीजें हमारे मन से अब धीरे धीरे सॉल्व हो गई होंगी. And we have with us another speaker, Mrs. Deepa Sharma, who is a member of the National Consumer Commission, and she will be talking about the practical aspects of the changing dimensions of consumer protection in India. Ma'am must be encountering number of cases. कंज्यूमर के जो हमारे केसेस होते हैं वो उनके फोरम में जाते होंगे और देयर आर वेरियस एस्पेक्ट्स ऑफ द केसेस, डिफरेंट टाइप ऑफ केसेस. तो शी विल बी स्पीकिंग, शी विल बी थ्रोइंग लाइट ऑन दैट. बिफोर आई ask our next speaker to start this session, I'll just give a brief introduction about her. Mrs. Deepa Sharma, she graduated from the Faculty of Law, Delhi University in 1978. She pursued law after completing her degree in Bachelor of Science. After having practiced law for nearly 2 years, she qualified the DJS examination and joined the Delhi judiciary as civil judge in September 1980. In a long and successful tenure at the Delhi Judicial and Higher Judicial Service, she has earned many laurels. Her most recent accomplishment is the setting up of family courts across different districts in Delhi. She was the first principal judge of the family courts and is responsible for creating the empathic culture and the streamlined process, which is the pride of these courts. She has embraced new and alternate practices in law, like mediation, and is a certified practitioner and trainer of the same. She established the Mediation Center at District Courts Dwarka. She has also traveled extensively to impart training in mediation as an alternate method to dispute resolution to various groups of lawyers and judges across the country. Before being elevated to the Delhi High Court, she headed the Dwarka Court as the district and session judge. She has gained a wide experience due to the various positions she held during her tenure as a district court judge. Some of these positions are Judge MACT, NDPS, Judge CBI, Sessions Judge for cases under ITP Act and others, Judge Labour Court, ACMM, Senior Civil Judge, RCT, etc. She has pursued academic interest and taken lectures on various aspects of law at Delhi Judicial Academy and National Law University. Her other interests includes poetry, music, and gardening. And she was elevated to the bench of High Court of Delhi as an additional judge on 17th April 2013. And right now, she is a member of the National Consumer Commission. Ma'am, please. Ma'am, you're not audible.
Thank you. Honorable Vice Chancellor, Professor Nagesha Rao. Am I audible now? Yes, thank you. Pro Vice Chancellor, Professor Sumitra Kukreti, respected Professor C.P. Upadhyay, Dr. Sunit K. Shirvastava, Director Soul, and dear audiences, on screen and off the screen, Namaskar. I really feel honored to be part of this event organized by the IGNOU. IGNOU is a world-class institution running a number of distance learning programs of higher education. This has benefited crores of students in attaining higher knowledge in different fields. I congratulate all those who are connected with this world-class institution for their hard work and dedication. I really feel privileged and honored to address such a wide range audience of IGNOU. Thank you. Professor Upadhyay has spoken extensively on the new dimensions about the new law and the consumer movement in our country. So I need not repeat all this during my this lecture. I would focus on the practical aspects of the consumer protection in India and the difficulties we feel, and also the pragmatic approaches we have, the courts have been, and the commissions are taking while giving relief to the consumers, despite many of the things not being incorporated in the old act. So in the older times, or 50, 60 years back, when local was vocal, consumers used to buy goods from the nearby shops, and the redemption of their difficulties were very, very easy, because the person from whom they used to buy goods used to replace it or change it, because they also all knew, known to each other. But now, when the scenario is changing, we have e-portal, web portal, and e-commerce sites where the consumer is not even aware of the face of the service provider or the site of the manufacturers. We buy the goods on the basis of details provided on the site. So we, as a commission, a member of the commission, always, even before this new act had come into operation, were aware of these difficulties of the consumers which they were facing, and for which there was no redressal mechanism under the old act. But still, by taking a pragmatic approach, we used to redeem and redress their difficulties. Now, the safeguarding the interests of consumer was always a paramount concern of the legislature, and this is evident from the various regulations which require the manufacturers to have certification of Indian Standard Institute ISI on their products. FSSAI, Food Safety and Standard Authority of India, deals with the regulation to control quality standards in the food products, etc. The agriculture products are required to carry the seal of ACMARC. The producers and the manufacturers are also required to follow the standards provided under the Standards of Weights and Measurement Act. Availing the service in buying the goods is a form of a contract, and the Contract Act provides the duties and the remedies arising out of a contract. Several other legislatures like Drug Control Act, the Essential Commodities Act, and MRTP, etc., were addressing the difficulties of the consumer before the passing of the Consumer Protection Act 1986. The expression of consumer was never not known before this act came into force, and for the first time, the general public who buys the goods has been categorized as a consumer, and their rights are recognized and protected under the Consumer Protection Act 1986. In 36 years since this act was brought to the statute book, the law on the subject is continuously developing, fulfilling the needs of society and the consumers. It is one of the most progressive and comprehensive piece of legislation taking care of the welfare of the consumers. Being a social welfare enactment and having its own challenges with the fast-changing needs of the society, the commissions and the Honorable Supreme Court, in exercise of its appellate jurisdiction, have always been adopting the pragmatic and practical approach to remove the difficulties of the consumers. The three-tier commission, district forum, state commission, national commission, all three of us have original jurisdiction, have been set up under the Act, providing remedies to the consumer. The procedure which we follow is very simple. We follow the procedure of summary trial where it's not a litigation like a civil suit where lengthy evidences are being led and extensive arguments are being done, and the entire burden is on the petitioner to prove its case. Here, on the basis, it's a summary trial in the sense that all the basis of documents and admission and denials by the parties, we decide the evidences are led on affidavits, and also the liberty is given to the parties to call the witnesses for cross-examination if need arises, and that too with the permission of the commission. Generally, this cross-examination sort of thing is done by exchanging the interrogatories, like enumerating the questions which need to be answered by the opposite party, and the process of cross-examination is minimized. I can say it's nil. It is not known. We do not generally permit any witness to be called and cross-examined. This is an act which provides an alternative, efficacious, simple, and inexpensive and speedy remedy. This remedy is not allowed to be curtailed on the ground that a complex issue of law and fact is involved, which requires scrutiny of documents and cross-examination. We refrain from directing the consumers to approach the civil court on these grounds, and the forums under the Consumer Protection Act are fully empowered to discharge justice to the consumers by adopting summary procedure. It has been so held by the three-judge bench of the Honorable Supreme Court in Dr. J. Merchant and others versus Srinath 2002 6 SCC 3635, where the Honorable Court has said that the Commission is fully empowered to deal with the matter, even if there are number of documents or the issue involved is complex. Whenever a complaint, appeal, revision petition is filed, it undergoes a scrutiny. The concerned official of the registry scrutinizes to see that it is free from any formal defects like jurisdiction, limitation, and contains requisite annexures and affidavits, memo of parties, and vakalatnama and the documents which is required to file along with the complaint as per the Act itself. Thereafter, if no defect is found or removed, it is placed before the appropriate bench for its admission. During the COVID time, the Commission allowed the consumer to file cases online using web portal e-Dakhil. We are still following the same e-portal for e-filing, and it can be filed, the complaint can be filed online from anywhere at the comfort of their own, and also pay complaint fee and monitor the status of the case online. E-Dakhil portal had been launched by NCDRC, by us, on 7 September 2020, and thereafter the facility was launched in 23 states, union territories, for respective state commission and district commissions. Our endeavor is to provide this facility to all the us around the country. The expression consumer is given definition for the first time under the Consumer Protection Act and is defined as a purchaser of goods for consideration and or the person who hires or avails any services excepting those which are done for commercial purposes. So if any person buys a good or avail the services for his business for commercial purposes, then he is not a consumer under the Consumer Act, and he has to avail his remedies in the before another fora like civil courts, etc. The Honorable Supreme Court in the case of Lakshmi Engineering Works versus PSG Industrial Institute 1995 3 SCC 13 clarifies the distinction between consumer who purchase the goods or avail services for his own use and the one who does it for business and commercial purposes. Even the farmers who are sold defect seeds by the government company or otherwise are declared consumers and compensated for such deficiency under this Act by the Honorable Supreme Court in the case of National Seeds Corporation Limited versus M.M. Madhusudan Reddy and others, 2012 2 SCC 506. Generally, we feel that a person has a family and he has two children, so he generally he wants to buy houses, one for himself, one each for his children. So he buys, suppose, 3 houses, and the builders from whom he buys the houses take this plea that because he has bought 3 houses, so he is not a consumer, he has not bought it for his own purposes, but his intention is he is an investor, and his intention is he bought it with the intention to sell it in future in the public and earn profit in the market and earn profit. But the Honorable Supreme Court has clearly held that in the case of Kavita Ahuja versus Shipra Estate 2015 SCC Online NCDRC 2747, this commission, not the Supreme Court, has come to the rescue of such bias, and we have clearly held that if the house is bought for the purpose of his living and for the purpose of living for his two children, then he is not he is not he falls in the category of consumers, and it is not bought for commercial purposes, and we reject the arguments of the builder that it is bought that he is not a consumer, and the burden is entirely shifted is put upon the builder to prove that that the person is dealing with in the business of buying and selling the houses, and that since it is his business, so he has intended to buy these houses also for the said purpose. But if the investment is done for the welfare of their children, his family, then we have clearly held that a number of pronouncements other than Kavita Ahuja, that he is a consumer within the meaning of Consumer Protection Act, and have granted relief to him. Also, if the various consumers, like in a multi-storied building, if there is a delay in giving the possession, all the consumers, all those who have booked their flats in that multi-storied, are the consumers who have similar interests and who claim similar reliefs. So this act itself allows, under 35(3)(c), the old act, new act also allows the same. So all those consumers can form an association instead of coming individually, can voluntarily form an association and file one complaint for redressal of their problems, the difficult, a joint complaint. However, if the caution is that if any act mandates that an association of such flat buyers is to be formulated, is to be made, then such association cannot file a complaint on behalf of the consumers. They are not treated as consumer. It has been so held by Honorable Supreme Court in Shobha Hibiscus Condominium versus Managing Director of Shobha Developers, appeal number 1118 of 2016, which was decided on 14th February 2020. Also, this commission, the builders, in the case of buildings, always come up with one excuse or the other regarding the delay in handing over of the possession. And they want that even if there is a delay, such a delay, huge delay, or a delay by 1 year or 2 years, if during the pendency of the trial before us, they are ready to hand over the possession, then they ask the commissions to ask the allottees to take the possession of the house. But this commission has held in several pronouncements that a builder, if has not been able to deliver the possession within the stipulated period, and after a reasonable delay, even if he is not in a position to deliver the possession, he cannot force the allottee to take the possession, and he is bound to refund the money along with appropriate interest rate and also damages and compensation. And this viewpoint was confirmed by the Honorable Supreme Court in the case of Pioneer Urban Land and Infrastructure Limited versus Govindan Raghavan, and civil appeal number 12238 of 2018. Also, now in the new act, it has been recognized that a wrong advertisement is punishable, right? They have to pay the penalty for advertising anything wrongly. But this commission which is but the Honorable Supreme Court has, even before this new act had come into force, had dealt with the difficulties of the consumers, where in a brochure certain promises are made, but those promises are not kept. And the Honorable Supreme Court has said that the builder is bound to provide all the facilities which he had promised in the brochure, even though those facilities are not part of their agreement, builder-buyer agreement. It has been so held by the Honorable Supreme Court in case of Wing Commander Arifur Rahman and others versus DLF Southern Homes Private Limited. Stop. Still, we feel everybody is aware that the directors of Unitech is already in jail, and the Supreme Court is coming heavily for their conduct and is keeping them in jail since 2017, since they have diverted the home buyers' money to their other projects, and they have been directed by the Supreme Court to refund that money, to deposit that money which they had collected from the home buyers with the registry, so that it can be returned to the buyers, and keeping them in jail since 2017, since they are not able to refund that money. Also, in the case of Jayaprakash Infrastructure Limited, who are pioneer in the construction field, when it is found that they are also diverted and siphoned off the money of the home buyers in other projects, the Honorable Supreme Court had taken care of that project and had and under a plan, they have appointed the NBCC to complete that project and hand over the possession to the home buyers. And this clearly shows that the judiciary, this commission and the Honorable Supreme Court are always trying to fill the gaps which the legislature has left, because the legislature even can't presuppose all the eventualities and the difficulties and the events. So we are always coming to the rescue of the consumers, because we feel that these are meant for the consumers only. Even the opposite parties, like the service providers, are stopped from taking advantage of this fact that since there is an arbitration clause in the agreement, so instead of coming to the consumer, the aggrieved party we should try for the arbitration. We should go for the arbitration, and the court has given the liberty to the consumer to choose the fora he wants to go to. Also, it is always considered an additional remedy, and it is said that no other provision can bar the rights of the consumer to come to this consumer fora for the redressal under the Consumer Protection Act. In that matter of insurance companies, we all know that whenever a claim is filed regarding any incident, the insurance company go on appointing the surveyors with the intention to get a favorable report from the surveyors. So the Honorable Supreme Court has come heavily on such conduct of the insurance companies, and in Venkateshwar Syndicate versus Oriental Insurance Company has clearly held that the report of the surveyor is of binding nature, and insurer cannot appoint second surveyor as a matter of course. It must specify cogent and satisfactory reasons for not accepting the report of the first surveyor, and the commission can even reject the report of the second surveyor when it feels that it has been done with the only object of procuring a favorable report from the surveyor in order to defy the claim of the consumer. we feel during our working that the another plea which the insurance company takes, that there is a delay in reporting the incident to them. We always feel that if a person is faced with a situation, he will first try to, handle that situation instead of immediately running to the insurance company and filing his claim. So we have taken a very pragmatic view in number of cases, and this pragmatic view is also confirmed by the Honorable Supreme Court, where the Honorable Supreme Court has clearly stated that the delay in reporting the incident to the insurer is not fatal, and repudiation of the claim solely on the ground that there was a delay in reporting the incident to the insurer is unjust and amounts to deficiency in service. Also, the another plea which the insurance company has been taking in the case of theft of the vehicle or the vehicle meeting with an accident is that the insured vehicle was being driven by a driver who was in possession of a fake license. So in such cases, we have come to the rescue of insured and have held that unless the insured is aware that the license was fake and still allowed the driver to run his vehicle, the insurance company cannot deny the relief to the consumer. And if it so denies, it amounts to deficiency in service on the part of insurer. In the cases of medical insurance, I have also come across with several pleas which the insurance company takes, and many of them is that certain information in the proposal form is not provided, or that the columns are kept blank. So we have thought in terms of the consumers for their benefits, and in such matters we have held that if before issuing the medical insurance, the insurance company had got the medical examination of the insured done, then all this, and had issued the insurance policy after getting satisfied, it cannot subsequently take such pleas and deny the relief to the insured. And it has been so held by the Honorable Supreme Court in a recent judgment of 2022, Manmohan Nanda versus United Insurance Company. Also, we have been facing a practical difficulty in the sense that the opposite party, that is the service provider or the seller, used to take inappropriate time or used to seek adjournments after adjournments before filing their written version. Although the Act provides that it should be filed within 30 days and plus the 15 days margin, but they used to file even after 45 days and then used to come with an application for condonation of delay, stating all sorts of reasons. And now this matter has put to at rest, and the Honorable Supreme Court, in order to protect the rights of the consumer and the early and disposal of the matter, has clearly held in New India Insurance Company versus Hilly Multipurpose Case 2025 SCC 757 that this Commission has no discretionary power to extend the period of limitation of filing WS beyond 45 days. So in case the WS is not filed by the service provider or the seller within 45 days, their right to file the WS is closed, and the decree is immediately, the order in favor of consumer is immediately passed in the absence of any defense. in 2019, this Consumer Protection Act 1986, under which we were working till July 2020, had been now repealed. And the new act incorporates many changes, as has been extensively discussed by Professor Upadhyay. And this new act incorporates all those changes which we have been mentioning in our judgments. And despite those changes not being incorporated in the old act, we have been giving relief to the consumers, keeping in mind the object of this act, which was to give social justice to the consumers. There is no doubt that the new act was a game changer. And new act has incorporated many new expressions like defective products, dissatisfactory services, unfair trade practices, and also especially mentioned that in manufacturing process, starting from the manufacturer till the supplier can be held liable by introducing the concept of product liability. The new act has also introduced the redressal of grievance by mediation by asking all the commission to establish the mediation cell. We at National Commission have established such a center. The new act has also established another redressal machinery like Central Consumer Protection Authority. It has also been given the power to recall the defective or dangerous or hazardous or unsafe goods and services, and also have asked for discontinuation of the unfair practices prejudicial to the interest of the consumer. If satisfied about a false and misleading advertisement, the central authority is empowered to issue direction or penalize the concerned traders and manufacturers or the endorsers or advertisers or publishers. We can say that the new act has brought a revolution in protecting the rights and interests of the consumer. At the end, I would like to say that the movement like Jago Grahak Jago should get impetus. Infrastructure needs to be revamped. Members of commissions in most places do not even have recent places to sit and work. They are not provided with proper staff. Despite all these difficulties and problems which they face during their day-to-day working, they are doing their best job to give relief to the consumers. It is the need of the hour to strengthen the district forum, state commission, and increase their numbers so that the justice can be delivered with speed. Thank you.
Thank you very much, ma'am. You have really given the practical aspects what you must be facing, you must be seeing what our consumers are facing there in the forum when they go to the forum for relief. Thank you so much. Now I invite Professor Sumitra Kukriti, Pro Vice Chancellor, who will be giving the presidential address. Ma'am, please.
Thank you. Honorable Vice Chancellor Professor Nageshwar Rao ji, who is the main motivating spirit behind the events of the university, my fellow Pro Vice Chancellor Professor S.K. Mohapatra, experts of today's webinar on World Consumer Rights Day, Professor C.P. Upadhyay from BHU, and Honorable Justice Ms. Deepa Sharma, Member National Commission of Consumers, Director School of Law, Directors of other schools, and other dignitaries who are attending this program virtually and on YouTube. Namaskar to all. It is indeed a matter of great pleasure that today School of Law has arranged this webinar on the occasion of World Consumer Rights Day. We know that World Consumer Rights Day is being celebrated since 1962 on 15th March every year. और जैसे कि सवाल उठता है कंज्यूमर कौन है, तो हमें बताया गया that a consumer is defined as someone who acquires goods or services for direct use or ownership rather than for resale or for earning profit. We know that consumer is the main component in business, but usually consumers are laymen like me. And if they are ill informed about their rights, there are very high chances that they may be duped by unscrupulous businessmen in their desire to earn huge profit. It's the consumer who has to shed the money for any product or service. So, therefore, his satisfaction is must and his rights must be protected at any cost. To make a conscious and reasoned choice and to get value for money, he need to know everything about his rights. We know that consumers are an essential part of a market structure. If consumer is not there, no business can take place. Therefore, it is vital to secure their privileges and rights. Consumer Protection Act 1986 shields the customers from any promoting misbehavior and cheating, and later the revised act in 2019 took the consumer rights to the next stage, as the learned speakers told us in detail about various provisions in this act. So, as per this act, separate consumer dispute redressal forums were established at state and national level. Each one of us present on this forum is a consumer, and very few of us, maybe the lucky one, believe that they have never been duped as consumer. At least I have experienced this feeling of being cheated on many occasions. And on those moments, I have regarded myself completely clueless about the future course of action, particularly in this age when the services have become very expensive and most of the shopping is being done through online mode, where the service provider is not present in front of us. So it is more than essential to become aware of our rights as consumer. All of us have witnessed that during COVID-19, all the schools and colleges were completely closed. The private colleges and schools deducted the salary of teachers but demanded full fee, which they got. Despite all kinds of pressure from government, the schools and college management had their way. We also know that a large number of private companies paid reduced salary to the staff on the pretext of loss in business, while the workload remained unchanged. All these issues demand serious thought. The lecture by Professor Upadhyay on new dimensions of consumer protection in India was very informative and relevant for the consumers like me. And the eloquent lecture by Honorable Justice Ms. Deepa Sharma provided information and exposure to practical aspects of consumer protection in India. Her wide experience in this field shall be beneficial for all the academicians who have joined this virtual webinar. I was listening to both the experts very carefully and was trying to imbibe the useful information. I appreciate and sincerely thank Honorable Justice Ms. Deepa Sharma and Professor C.P. Upadhyay for enlightening us with their views. I realize that the school chose their experts very consciously. One is a professor, a male professor, who transfers his knowledge about consumer rights among his students, and the other expert with these affairs, is has shared her knowledge as part of a profession. It was really wonderful to listen these two veterans who are contributing in the field of consumer rights in their own manner. So I would like to congratulate School of Law and the director Suneet K. Srivastava and her team for organizing this webinar on the occasion of World Consumer Rights Day. Congratulations and thank you one and all. Namaskar.
Thank you very much, ma'am. It was really indeed very rejuvenate. I feel very rejuvenated to listen to you when you said that we have organized this very nicely and we have chosen the two people from different fields, one giving the practical aspect and the one from the academy. Yeah.
आवाज आती है सर?